Hello everybody, it's Rick. I'm just documenting. I'm going to be heading to federal court today, or district court, and also going to be heading over to family court. What people need to understand that this journey of dealing with criminals working in courts, it takes a while. Okay, I filed this, as you can see, the first numbers is 15. I filed this July 23rd, 2015, and on November 2nd, 2015, this United States District Judge, Margot K. Brody, dismissed it. And as usual, she didn't cite any evidence. She accepted a motion to dismiss by the Assistant New York State Attorney General. Now, the New York State Attorney General, people need to understand, is the people's attorney. But what they usually do, if anybody lives here in New York, you'll see this clown, Eric Schneiderman, on TV. He's nothing but a shakedown artist. All they do is they sue any profitable businesses like the FanDuel last year. They just try to shake people down. And what they do is part of the shakedown, because New York shakes down people like you and I in family court. They shake down if you park your car on the street and you get tickets, and if you're arrested, unlawfully detained. What usually happens is when you sue a state agent or state employee, the New York State Attorney General's office represents the wrongdoers who are depriving you of your rights under color of law. Now, what color of law is the appearance of law, but it's like family court. You think that you're in a courtroom. Remember, I keep telling you, go in there, you got a fake judge they call a support magistrate. Everybody's calling her Your Honor and Judge. You got to stand when she walks or he walks in, and it's all bullshit. It's color of law. But the hardest thing to do is to get these people to answer for their trespasses. So what I did last year is I filed, and things were pretty tough, but I had to take $400. I mean, it's expensive, and that's done on purpose. Now, the fees in the courts are really for lawyers. But as with everything else in this crazy world we live in, they take a law or rule that applies to a small percentage of people, and then they apply it to everybody. And then it's up to you and I to rebut the presumptions. And there's a lot of presumptions. So the fees are really for professional lawyers because they're always in the courts. But what they've done is they've applied it to everybody. So what they do is you go to court, like, this is the civil docket for my case. And they have, where am I? They have me as pro se. Okay? I've made it known in papers that I do not wish to be termed pro se. Pro se means is I'm basically acting as a lawyer for myself. Why would I want to do that? I don't want to be a lawyer, because if I'm pretending to be a lawyer, I'm bound by their rules. So all the federal rules and procedures are really meant for lawyers and federal employees. They're not meant for you and I. The rules you and I have to follow is the United States Constitution. Okay? The federal rules and procedures are really meant for lawyers, federal employees. But they, again, remember, the small percentage of people, they apply it to everybody. So, anyway, this woman dismissed my case. The United States, the New York State Attorney General's office, he issued a motion to dismiss, one of those standard things. I failed to state a claim, meaning that what I'm saying is without merit. And what this slickster did, all the evidence he submitted was all the evidence I submitted. So he just took my evidence, photocopied it, and submitted it, which is pretty funny. So in other words, he was just trying to make his motion look like it had some substance, but it really didn't. And most importantly, his motion to dismiss was without any sworn affidavits or affirmations from the wrongdoers, who are all New York State employees. So in reality, they never responded to my claim because the assistant district attorney for for New York State, Attorney General's office, he's a third party. He has no first person knowledge of this. So anything that he says is hearsay. So the way it's really supposed to work is the people are supposed to, the wrongdoers are supposed to craft an affidavit stating Richard Wildman is wrong. I advised him of his rights. I did this, I did that, I did the other thing. And then he signs at the back, sworn under perjury. But none of them did that because they know if they did, they would be liable even further. So it's a little slick game they're playing. Anyway, I expected all of this stuff to happen. So, you know, when this judge, Margot Brody, and I've never seen this woman, by the way. I don't even know what she looks like. We're playing tag through the mail. They're funny. They hide. You know, the big, powerful United States District Judge is hiding from me. But before November 2nd, because I expected this to happen, I took what you need to do is you need to notice the courts of everything to cover your rear end, because down the road you're going to have to sue these people. It's never going to be easy. And I've stated it before in my other videos. You're not going to send some piece of paper to them and they're going to go, oh, he's got us now. We might as well give him back all his money. That doesn't happen. Okay? Look at me. It's over a year. And she dismissed my case. And by the way, they're still accepting papers from me. Okay? I'll show you. Okay, this is the updated civil docket. Okay? I have it, and what I'm doing is I'm entering it as an exhibit, as evidence, as proof that I've submitted all of these notices to the court, for which Brody ignored. Okay, look at this. These are a bunch of pages. Motion to order to show cause. On this date, I was in there for 2.5 hours asking Margot K. Brody to show cause of why she refuses to void the void judgment. The family court judgments are void because they don't have, remember I keep telling you, it's not recorded in the clerk's office, it's not signed by a clerk. And I cited you the case law that says that it's void for lack of judicial signature. They notice. So listen to this slick move. I'm in there for 2.5 hours. They got me waiting around like a jerk. And then out of nowhere they tell me, oh, they're not seeing anybody today. And what am I going to do? I'm going to go up there and start going crazy? No, you can't. So, I mean, you can, but you know, sometimes you're better off trying to be a little more civil. You know what I mean? Because then they start labeling you things, and people see you. People maybe will believe whatever they tell them. Like in family court, they labeled me belligerent. I'm followed around by a lieutenant. And if you, in my video, and by the way, that video, my last family court video, I privatized it for private viewing because until my case is over, I don't want to anger the people over there and delay this any further, okay? So that's the reason why I kind of took it down. But I'll put it back up when this is all over. But they termed me belligerent, and the judge, I said, do I seem like a belligerent? He goes, no, you're very, you know, I was cordial. I know how to act. I'm not, you know, I don't walk around like a meathead. You know, I know how to speak to people. But, you know, if you speak to me like an idiot, I'll talk to you like an idiot. Anyway, the summary, the order to show cause was then given to the chief judge, Dora Lizette Irizarry. She's not assigned to my case. So she denied my order to show cause because the questions I asked were like, is the Constitution repealed? Has the Constitution been suspended? Since when did the Fourth Amendment, my, you know, right, that My property can't be seized without a warrant. When was that repealed? So she knew she couldn't answer these questions. So she gave it to another judge. That doesn't make any sense. Okay, that's just them, sidestepping what I was, my notice. So that's good for me. I mean, it's not going to happen overnight, but it's good for me because it's showing that they're avoiding me because I'm right. Okay, I'm right. So these are all things I filed. Okay, everything, all these notices, and I did this on purpose to back me up at a later date. Now I'll show you what I did. And I'm entering all of these now. I objected to being called pro se. I noticed the court that I'm convening a court of record. And when you have a court of record, the judge is not allowed to act independent of the jury. You understand what that means? That means they cannot issue summary judgments. The jury has the power to do all of this because the jury is actually the one deciding and not the judge. The judge is a referee. The judge in a real court of record is not even allowed to give the jury instructions. They're supposed to, but they do it all the time. Why? Because you watch shows like Law and Order, where they program people. This is stricken from the record. The judge is not allowed to do that in a real court of record, people. And so I told her that. The default judgment. Well, that's because the wrongdoers did not offer a signed affidavit in response to my claim. Their attorney did, so I filed a judge default. Notice of motion. I want full restoration of my property. Now, a writ of mandamus. Remember I told you about a writ of quo warranto. It's all in the same. It's under 28 U.S.C. section 1651. It's the old writ section. Now, there's case laws about void judgments. Writ of mandamus, what it is the court is issuing a writ to a lower court stating they're not allowed to do whatever, or they should restore property. They're giving instructions to a lower court. That's what I did. And I also put a bunch of case laws. This notice is a notice that I told them that they have to adhere to the Constitution of the United States. This is I filed this right away, is relief from a void judgment. Ignored. So what I'm doing is, now I'm going to the court right now, and I'm adding Brody to the docket. It's because I'll show you real fast over here. This is PACER. If you ever heard me on here, I talk about PACER, okay? And this reflects everything that's happened in the case, and it's a lot. So on the 13th, I went to court, and I filed a notice of demand, writ of quo warranto, writ of prohibition, writ of mandamus to void judgment. And for a little while, they weren't putting all this precisely on me, and I had to threaten to sue them. So they started following what I was saying. And everything that I've done is shown on the computer. So if anybody was to access PACER and you look up my case, okay, now it states it's terminated, but I'm fighting that. That's what the writ of mandamus is about. A termination is not permanent. It could always be withdrawn by a writ of error. The courts make mistakes all the time. Okay, so what I'm going to be doing now is, by next week, it should reflect that I am listing Margot K. Brody as a wrongdoer now. She's going to be a wrongdoer on this claim because she deprived me of my rights. All right, I put all the evidence I put there, and what you got to do is you have to rebut all presumptions, because these judges, that's all they do is they presume this, they presume that. So they presume that the people that you're suing, if they're employees of the courts, they have judicial immunity, which is a clever scheme to bypass due process. Now, it's impossible. I wrote it here. It is impossible under the United States Constitution for a man or woman to be judicially immune simultaneously while depriving due process and trespassing on rights of Richard Warmer Jr. Any federal or state agent risks being held personally for damages. The wrongdoers all fail to ignore color of law statutes, therefore must be held to answer. If as an employee of the state, if you see a law that you think is unconstitutional, you don't have to enforce it. Okay, that's what that means. All right, I'm running out of time. I'm going to get out of here, and I'll let you guys know what happened.